This season of Trucksafe Live is presented by LogRock. LogRock builds technology tools to help trucking companies stay compliant with federal and state regulations. LogRock is easier. We connect to multiple systems like your FMCSA account and ELD, so you only have to use one system. LogRock is faster. We automate tedious tasks so you can use your time more effectively. LogRock is smarter. We notify you of issues like expiring or missing documents before they happen, so you can be proactive rather than reactive. Setup is easy, and most of our customers are online shortly after signing up. Request a demo now at logrock.com.
Hey everyone, welcome to episode 14 of Trucksafe Live, the monthly show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon with Trucksafe and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. Today we're talking about broker liability. We're going to give carriers a rest. Most of our shows are all about the problems that motor carriers face. Today they get a break. We're going to talk about the problems that property brokers and even shippers tend to face. Before we do that, a few things going on in the industry. Of course, the big news this past week, it's been about a week, I think. FMCSA published an advance notice of proposed rulemaking, ANPRM, concerning ELDs. This is potentially the first substantial revisions to the ELD mandate since it went into effect in 2015. And so it has the potential to be a pretty big deal. If you're interested in the details of it, we just put out a detailed article over at trucksafe.com and a video on it. But long story short, there's essentially four parts to it. The agency is soliciting comments from the public in essentially four areas. Number one is the exemption that exists in current rules for pre-2000 model year engines. So as many of you will know, those drivers of those vehicles with pre-2000 engines are completely exempt from the ELD mandate as it stands. The agency in its notice mentioned that it has heard, apparently through the grapevine, that certain rebuilt engines, older engines, have the electronic control modules or the ECMs that are in fact compatible with ELDs. So they are considering doing away with the exemption or potentially modifying it. So they're soliciting comments on that. So that's a big one. The other issue that they're looking at are how we handle malfunctions. What happens if one of your ELD devices malfunctions and drivers aren't able to use them to track their records of duty status? Under the current rules, there are certain situations where there's been a malfunction and drivers have to transition over to paper logs. There's a whole process that drivers and carriers have to go through when a device malfunctions, and the agency's asking whether it needs to be more clear in its regulations about that process. I think the answer to that is probably yes. It always helps if we can bring some clarity to those often complex issues that drivers and carriers are expected to deal with. Then we have some potential revisions to the technical specifications of the ELD rule. These are the specifications that will apply to the devices themselves. What do they have to be able to track? What types of data do they have to collect? That type of stuff. The rules that the manufacturers of the devices have to be concerned with. There's a handful of specific questions the agency is posing in its notice about the technical specifications. The one that really caught my attention was the idea that the agency is thinking about allowing the devices to automatically change a driver's duty status if that driver forgets to change the duty status before powering down the truck. We see this come up quite a bit when we go and do audits of motor carriers where we'll be auditing a driver's logs and we'll see hours on end of personal conveyance time or on duty not driving time, which usually indicates that the driver forgot to place him or herself out of that status before powering down the truck, and then they just left themselves in that status over the weekend or something like that. And that leads to trouble, obviously, in the event of an audit or roadside inspection. So under the current rule, the devices can't automatically switch a driver's duty status in that scenario, so the agency is contemplating changing that. And then last but certainly not least, the agency noted that it is considering potentially moving away from the self-certification process that we have in place in the U.S. for device manufacturers. So, this is a big difference between the U.S.'s ELD mandate and the Canadian ELD mandate. In Canada, if you're a manufacturer of ELD devices, you have to have your device certified by the agency that regulates highway safety in Canada in order to offer that to motor carriers. In the U.S., it's a self-certification process. So we rely on the manufacturers of those devices to certify that their devices meet all of those technical specifications. And we're starting to see the FMCSA be more aggressive in revoking devices that turn out not to be compliant with those rules. So the agency is now posing the question, should we move away from this self-certification process and to a process where the FMCSA itself or its designees step in and certify these devices? Obviously, that would be a huge change, and I imagine it's making the device manufacturers pretty nervous. Long story short, those are the areas where the agency is contemplating some changes. Comments are due by November 15th. If that's not extended, it probably will be extended, it would be my guess. We're a few days into it, and there are already several hundred comments. So if you want to submit comments, look it up at regulations.gov. Docket number FMCSA 2022-0078 is where you'll find that, and then you can submit your comments. If you have any questions about how these potential rule changes may impact your operations, or if you want any help submitting comments, feel free to get in touch with us. We're going to help a couple of different groups submit comments, so that's something that we've got on our plate. Again, if you need help, feel free to give us a call or reach out, trucksafe.com. All right, aside from the ELD notice, there have been a couple of other notices that the agency has recently released. One is a notice concerning the ongoing COVID emergency declaration. So this is a declaration that the FMCSA issued way back March of 2020 when COVID was just ramping up. And it's a pretty broad exemption from, it started out as a pretty broad exemption from most of the safety regulations for drivers and carriers who were engaged in the emergency relief efforts, transporting, testing supplies for COVID testing, or transporting nowadays supplies to restock shelves. So it's been kind of an all-encompassing exemption. More recently, the agency has kind of cut back on it, and now it's mainly an hours of service exemption. Again, only available to carriers and drivers that are actually transporting goods that are part of the emergency relief efforts. The notice that just came out this month is trying to get a feel for how many carriers are still taking advantage of this exemption and how they are using it. To me, this kind of spells the end for the declaration. It would not be surprising to me if the agency were to phase it out completely here over the next month or so. So we'll see where that goes. If you are still using it, be sure to get in there and file your comments so that the agency knows you're still using it. And then lastly was another notice that came out yesterday, I think. This one was interesting. This is a notice from FMCSA seeking some information on human factors pertaining to the operation of semi-autonomous trucks. So we've seen some news stories recently of some things that have gone wrong with certain semi-autonomous trucks where there's a safety driver in the seat, something goes wrong, a truck gets involved in a wreck. Clearly this is on the agency's radar, and now they're starting to kind of study this. So if that interests you, take a look at the notice. Again, FMCSA just released it. We'll see where this goes. The agency hasn't really done anything yet with autonomous trucks. we've talked in the past that there's going to have to be really a kind of a wholesale revision to the safety regulations as they exist currently, because right now the way the safety regulations are structured, they fully contemplate that a driver, a human driver, is operating the trucks. That's just how the regulations are structured. Clearly, as we're moving towards autonomous trucking, we're going to have to revamp the regulations, and the agency needs to get on that sooner rather than later, in my view, because we are there. We are at the point where autonomous trucks are a reality. So it is what it is. We'll see where the agency takes it. All right, that's all the news I have for industry-related news. A couple of things going on with Trucksafe. If you haven't checked it out already, make sure you download our app. We have the Trucksafe Network app in the App Store and the Google Play Store. This is where you'll have access to our Trucksafe Compliance Network, a space for safety professionals, risk advisors, insurance professionals to gather together, ask questions, learn from one another, learn what they're doing well, what's working well for their fleets in terms of managing a safety program. The app also has all of our DOT-related articles available and our full library of DOT-related content. So check that out. Just search Trucksafe in the App Store or the Google Play Store, and you will find it. Also, another related news for the Trucksafe Compliance Network. If you're not a member of that yet, be sure to join that. It's free to join. We offer a lot of free content to folks that are members of the network. Go to trucksafenetwork.com. Again, free to sign up. We just recently did a free webinar on drug and alcohol testing and some of the problems that tend to arise for motor carriers in that process. We're doing these types of free webinars at least once a month. So if you are managing a fleet of drivers and your responsibility is staying in compliance with the multitude of regulations that govern your business, be sure to check that out. We're just trying to offer this content, get it out there in the open so folks have access to it and they can better manage their safety programs. So check that out. Lastly, check out our courses online, trucksafeacademy.com. We've mentioned this before, but we have a full catalog now of in-depth, comprehensive courses on DOT compliance. We have one for safety managers. We have one for drivers. We have a hazmat-specific course, and we have a reasonable suspicion course. So check those out, trucksafeacademy.com. All right. That's it with all of the news that I wanted to talk about. So let's turn to the topic of today. Again, the show today is about broker liability and some of the exposure that property brokers and to some extent shippers have. How brokers tend to get implicated in highway accident litigation and what they need to do to protect themselves. With me today, I am excited to have on with me none other than the Armchair Attorney, Matt Leffler. Matt, welcome.
Be here. Thanks for having me on the program.
Awesome. Hey, I've been wanting to get you on for a long time. Really enjoy your content that you're pushing out. Excited to have you with me today. So give us, for folks who aren't following you on social media or wherever you post your content, give us a little background, how you got involved in transportation and what you do for the transportation industry.
Like so many people, this is a family business. My grandfather hauled grain in central Illinois until polio took his ability to walk, and he became a mechanic after that. And my father was 8 years old when he started turning wrenches to help my grandfather. And in 1976, my dad started with Roadway as a night shop supervisor. And he managed union mechanics for most of his career. And in the early 90s, he had the opportunity to start his own business. And the business he started was a company called Outsourced Fleet Services. And Outsourced Fleet Services outsourced fleet services. We did repair and maintenance for commercial vehicle fleets. And our biggest customer, the biggest one we worked with to begin with, was a company called RPS, which eventually became a FedEx Ground. We were the largest provider of maintenance for ground for about 20 years. And I joined up with the company after completing law school and practicing for a couple of years in the business. And we grew that into an organization with over 100 mechanics in 6 different states. We sold that business in 2018 to a company called Dickinson Fleet Services. And I stuck around with Dickinson for about a year and a half as a vice president of sales. And then I had a non-competition agreement, and I spent some time in software. I went to a company called Decisive, another one called VHub. And after that, I wanted to get back into the maintenance business. So what I do today is I have kind of a couple roles that I run. One is the founding partner of Armchair Attorney. It's a law firm that helps people and companies create post-employment restrictive covenants and separation agreements and that kind of stuff. And I also work with a firm called Epica Fleet Services, which is a repair and maintenance vendor. We have locations all across the country, over 150, maybe close to 200 mechanics right now. And it's been an exciting thing. So this is what I do. I love this business. You can't get out of it once you're in it. And I'm excited to be part of the network that is the Supply Web.
Yeah, well, I mentioned your content at the start here. That's kind of how I came across you, just watching some of your live shows that you do. Tell us about the podcast that you do.
Yeah, so I started off by saying, what is a website domain that I can get? And that domain was Armchair Attorney. So I said, well, that's a really catchy name. It's got some alliteration. Might as well trademark it and form an LLC, which is what I did. And then I started producing these interview shows. So before I did the interview shows, I was doing just content around non-competition agreements or just different legal topics, things like the Second Amendment, just topics like that. And what we did was we started doing these live interview shows, and they really seemed to catch on. And we've had some incredible guests over the last couple of months we've been doing it. And then we tunes or with the Apple Podcast or Spotify and look up Armchair Attorney. You'll see my vector image face that my wife made for me. And you can see the interviews we've had with a whole bunch of really interesting people. Just last week, we had Britton Ladd, who is a global supply chain consultant, one of the most brilliant guys I've ever had a chance to work with. And it's just a lot of interesting things like that.
Yeah, that's awesome. If you're not following him already, do yourself a favor, do that. Go to, he's on LinkedIn. Where else are you? Facebook?
Yeah, so thank
Twitter.
you, man. I've reached it. So on Twitter, you can find me at Armchair Atty. It's ATTY. ATTY is the abbreviation for the word attorney. On TikTok, I do have that now. It's Armchair Atty as well. You can find me there. I think I have 4 followers. So
yeah, we were just talking before the show about TikTok. It's a completely strange world.
I have no idea how any of it works. I'm barely competent with Twitter. LinkedIn is where I do the most amount of my content. But I go on all sorts of different programs. That's how you and I got a chance to talk earlier, was on FreightWaves together. So it's a thing that I love to do. I love talking to people. I love making content.
Nice. Yeah. Okay. So we are talking today about, in fact, this is how this topic idea came up. We were talking on FreightWaves together. And one of the topics that came up in that show was broker liability and the C.H. Robinson case that came out. It's probably been a month or so ago. And, we've heard a lot of talk in the industry about this AB5 case. And I know you've spent a lot of time thinking about and talking about that case as well. But one that I think kind of got papered over a little bit by the AB5 case was the C.H. Robinson case. I'm wondering if you could give our viewers kind of a high-level overview of what this case is, what it does, and what its implications are to the industry.
Yeah, the main thing to start off with is don't panic. This is how the law works. But the case goes around where Costco hired C.H. Robinson to move freight. C.H. Robinson then hired a carrier, and that carrier performed the move. Unfortunately, that carrier lost control across the center line and struck another vehicle. And what ends up happening is everyone gets sued. So when someone has a catastrophic accident, you try to figure out where you're going to find the way to recover for your plaintiff, for the injured person. And what ends up happening is C.H. Robinson tries to make the argument that they are essentially immune from litigation, that they are preempted by a statute called the FAAA that essentially says you don't get to regulate the way that I do my business. Now, the FAAA preemption has to do more about pricing and things like that, whereas a negligence claim, which is what's being alleged in the C.H. Robinson case, is generally looked at as a safety issue as opposed to some sort of means or methods of making transportation. And so what ends up happening is every broker starts saying, wait a second, the whole idea of what I do is to outsource the risk to somebody else, and I'm not responsible under any of these circumstances. And a lot of people have been thinking, well, does this mean that brokers are now going to be liable more often? And first of all, no one said C.H. Robinson's liable. The fact of the matter was that you can proceed with litigation against them, which just means that you can find out if they might be liable. But that's what the meat of that case has to do.
Yeah, I think that's the misconception that I've seen quite a bit of talking with clients and kind of talking about the case. It always comes up and everybody says, well, it's going to be a sea change now. Brokers are going to be pulled into these cases. It's like, that's not really changing. That's how it's been for decades.
This is the thing, as a lawyer yourself, like, there's not that many new things. Like, there are new things, But these types of liability and these theories of recovery have been around for decades. Like negligent hiring or negligent retaining of a motor carrier is not new. Every state has these every single year. What is new-ish was that they brought it to the Supreme Court and they thought they might have an audience. Maybe the Supreme Court would say, yeah, let's grant the writ of certiorari and we'll hear the case. But the Supreme Court's like, no.
Yeah. It would have been a huge change had the Supreme Court weighed in and sided with C.H. Robinson and said that F4A preempts these types of
100%.
claims.
Yeah. And the thing is, like, all the interest groups, the lobbying organizations, and the greed, conglomerates of, Truckload Carriers Association or ATA or TIA, we're all filing briefs, amicus briefs, saying, hey, take this case. It's really important. We need to make sure they have no liability. And I think a lot of people expected something to happen that didn't. And now there's a little level of, I wouldn't say panic, but if you're a broker, carry adequate insurance.
Yeah.
That's a simple thing to start off with. Like, you can have good practices, good processes, good technology, but just carry enough insurance and you're probably going to be okay.
Yeah, a lot of the big brokers are well aware of this exposure, and they do just that. I don't think a lot of the smaller brokers even realize that this is a concern, and they don't realize that there is insurance coverage out there available specifically to address this type of exposure. That's one of the things that we've worked with our broker clients on is, hey, there's broker liability policies out there. You need to go check those out for sure. So you had mentioned kind of how these cases play out and the theory on which the brokers and even shippers, frankly, get pulled into these types of lawsuits. Maybe we should break that down a little bit and kind of explain what is this idea or this concept of negligent hiring, negligent retention, negligent selection.
Yeah, absolutely. So negligence is one of the most interesting things you're ever going to learn about in law school. And really what it boils down to, besides...
Is it really that interesting?
That is what all litigation's about, man. This is almost every theory of recovery, from falling, a slip and fall, from a car accident to a truckload liability to any type of workmanship. I mean, this is the question of what is the duty, what was the causation, what was the proximate cause, and all these other, how did you relate to that event, and then what was the damages. So as lawyers, we tend to know what the damages are. We say, what was the injury? What was the someone died? Did someone get, maimed? We know what those things are worth. Workers' compensation is all about understanding what is the relationship of money to injury. And the question we then go back to is, who's responsible? Who pays? Now, if you are a plaintiff's attorney and you have an injured person you're trying to help make whole, and they're not negligent themselves, and we can talk about, contributory negligence, but you're asking the question, how do I help my client? Who's responsible? You look at the truck carrier, and you say, how much liability do you have? They have $1 million. What does $1 million buy you? Nothing. Even the Department of Transportation has the statistical valuation of human life at $11.2 million per human life. That's the value that they assign. And we know the value of human life in most cases across the country. And if someone dies, you can't make them whole with $1 million. So you look and say, well, who else was involved with this? And as a plaintiff, I have no idea the level of responsibility, the communications that took place, the processes involved. And so I want to find those things out. And that's how these other companies start getting dragged in. Not just the broker, maybe the maintenance provider, maybe the tire provider, maybe the manufacturer. What are the different things that went wrong that caused this catastrophic thing to happen?
Yeah, so obviously, it's a completely, I won't say completely, it's a different theory than the plaintiff would bring against the truck driver or the trucking company that employs the truck driver, right? Because in that case, if the truck driver was at fault, your theory is that the driver was negligent in his operation of the vehicle, and his negligence caused my injuries, and so he owes me. And then the way that we get to the motor carrier in that situation is that kind of employment relationship. Yeah. Vicarious liability, you'll hear that term thrown around. It makes employers, or even we have a unique thing in the transportation industry where we have a lot of independent contractor relationships, and nefarious trucking companies over the years have tried to sidestep their liability by setting up these independent contractor relationships. But the DOT is wise to that tactic, and they put into place these leasing regulations that now there has to be a lease agreement in place when you've got owner-operators between that owner-operator and the trucking company. And that, in essence, then makes that motor carrier liable for the actions of that driver, regardless of whether it's an independent contractor relationship or not. So that's how drivers and motor carriers get implicated in this type of lawsuit. But when it comes to the brokers and even up to the shippers, I think your point's a good one. We're looking up the chain to the deeper pockets. If we can only collect $1 million, we're lucky if we even get $1 million from trucking companies. I think correct me if I'm wrong, I think the minimum insurance of $750,000 for general commodity carriers has been the minimum since like the 1980s. We have not raised that bar since then.
And there's not a lot of people asking for it to be raised. And in my opinion, you need to have higher levels of insurance. If you want to stay in the business, you need to have longer. You need to have more. But to your point, like, how did the broker get liable? Well, we look and say, well, what was the duty of care? Like, what was the process that you used to select this trucking company? Because but for you having selected them, my loved one would still be here, or my leg would still be working. And it's a harder case to prove. But once you get them on the case, you have the power to do discovery. You can find out what they were doing. And then as we look at what we call joint and several liability, it might be the broker's only responsible for 10% of it. That's fine. I'll take all the money from you anyway. Because we're jointly and severally liable. Everybody is fully responsible for the action that takes place.
Yeah, I think that's a huge point that so many miss, is with joint and several liability being kind of the law of the land. If that motor carrier has $1 million of insurance, let's say you've got a $11 million lawsuit, that motor carrier, tenders its $1 million, they're out of the picture now. They're lights out. And so now you as the broker are on the hook for that remaining $10 million, even though you may be only 10% at fault.
Absolutely. And it gets really complicated. So to your point, the insurance company for the motor carrier may say, all right, you've maxed out the policy, but I still have to defend you. But that liability, that insurance provider might turn around and say, okay, I'm going to subrogate. I'm going to go along with you against the broker or whatever. So these things get complicated very quickly. And if you have that $1 million policy, every carrier needs to understand this. Your limitation of liability is not the amount of insurance you carry. I have liened assets. I have foreclosed on real estate. If I have a judgment against you and your insurance is exhausted, I don't care. I don't care. I'm going to get the money from you. If you have any resources, I will find them. I will lock your bank accounts. I will siphon the money off, and I will give it to my client. So it is not in your interest to carry what's legally minimum in terms of insurance. If you have one catastrophic thing, you could lose a whole lot more than just a load of freight.
Oh yeah, for sure. We see studies out there. The American Transportation Research Institute did a couple of great studies recently. If folks listening haven't checked those out, make sure you do so. Yeah. One's on nuclear verdicts that you hear a lot of talk about. The other's on verdicts that are less than $10 million. $10 million is the way that the study looks at these types of verdicts.
Yeah. All right, we're going to take a second here, Brandon.
Yeah, let's do it.
I'm going to plant a flag here. I don't like the term nuclear verdict. It's not a legal term. It's a made-up term. And here's my theory on it. And you can tell me I'm wrong. I think that nuclear verdict is a phrase used to manipulate people to think we need to have additional tort reform. The idea being that a verdict over $10 million is like a catastrophic end of the world type of situation. It's just completely wrong. One human life, one wrongful death case is going to be over $10 million in most contexts. And we don't say, oh, that's that car accident, that slip and fall, that's a nuclear verdict. No, it's a verdict. It's just a verdict. It's just a verdict for a dollar amount.
Yeah, I see your point. I would disagree with you on the need for tort reform, and we could spend hours on this topic alone. I think, in my view, tort reform is necessary, not so much because of the way we sensationalize these types of verdicts, but because of the way we've seen at least some of these cases play out with this whole reptile theory of litigation. And because in my view, certainly the injured plaintiff needs to be made whole. If we're responsible for the accident, we need to make sure that they get what they're entitled to get to make them whole. What I have a problem with is then taking that the next step and saying, that's not enough for us. We want to punish the motor carrier, not necessarily for the circumstances of this accident, nothing to do with this accident, but rather their safety-related reputation. what do their CSA scores look like? What have they done from a driver qualification standpoint? In my view, that's less relevant to the accident at hand and making that particular plaintiff whole from the accident. And it's really about just, punishing that motor carrier for behavior that may or may not have led to this accident at all. And I think that's where most will say that we maybe need some tort reform. And there are certainly states that have pursued that. Texas, for example, recently passed some tort reform in that regard.
Yeah, the thing that I get concerned about is that we make it seem like the plaintiff doesn't deserve what they get, and like what a jury returns in terms of a verdict for somebody, that's sacred. That's something that's very important, and we don't want to find a way to make it so that a plaintiff is vilified for simply trying to be made whole for the things that they've encountered. Am I glitching here, Brandon?
You're freezing up a little bit, but we're going to push ahead. We're going to push ahead. No, this could be my fault. Hey, we got a question here. Let's bring it up here. Let's see what it says. Whoa, that's huge here. Let's make it a little smaller.
Hey, Barry, how you doing, buddy?
Barry says, that's like if a broker would put a fine on a carrier for a late pickup or late delivery, which now some shippers are starting to do. What scenario would come out if the carrier had an accident and simply state, I was in a hurry because I did not want to get a fine from the broker or the shipper?
That's a great question. I mean, if you have a broker who's basically saying, hey, I want you to skirt safety or skirt these things, that's a path to get liability, especially if you're telling them which way to go or what direction to use. This is the lack of the hands-off control brokers need to have in place in order not to be liable. That's a great question.
And that's exactly right, because I think the interesting thing about broker liability is if you're a broker, you're having to you're having to balance two things, right? You're balancing one, doing enough to make sure that the carriers you hire are safe and should be out on the road. But if you start to meddle too much in that motor carrier's business and start to tell the drivers what to do and start to impose these types of fines that Barry's talking about, then you expose yourself to a different type of liability, which is what we call joint employer liability, where now you're involved in that motor carrier's and that driver's business so much that you almost become an employer of that driver, just as the motor carrier. And so now you're liable, but you're liable under a different theory, which is the same theory that the motor carrier itself is liable on. So you've got to kind of balance that scale and find kind of that right balance for sure. So I guess that kind of leads to the question, the $1 million question, which is what exactly is the duty of the broker or the shipper in terms of selecting a safe carrier? What do they have to do to prove that they've taken the steps that are necessary to vet these motor carriers, essentially?
Well, you know the answer to this, and the answer is it depends. It's always the answer. It always is the answer. It's going to vary state to state. So keep in mind, negligence and negligence claims and the duty of care and how they interpret the duty of care will vary from state to state. There's no federal negligence statute, for lack of a better word. And the duty of care that is looked at is what is reasonable for that broker. And that'll depend, again, on the state and other cases that have happened. But in a nutshell, you always kind of have this duty of reasonable care. And the selection process has to be at least kind of on par with what the industry uses. So if you're just dialing random DOT numbers and saying, hey, can you move this thing for me for $500? And that's the extent of your research, that's probably not going to be sufficient. You need to, I'm not going to give any legal advice here, to be honest. But there is technologies that can give you information about a carrier and how they perform typically. You can call references. That's another way that people have done it for decades and decades and decades, and you still can do that. But that's a really good question. It's going to continue to evolve as technology becomes more ubiquitous in how we select trucking companies.
So I think this was the concern, the prime concern in the C.H. Robinson case was this potential for a patchwork of state laws on what exactly is the broker's duty. What lengths do they have to go to vet a motor carrier? And the idea or the argument was, well, the federal law steps in here and preempts this, so we don't have to look at it on a state-by-state basis. I could kind of see that, but at the same time, in my view, the standard as it stands right now is fairly uniform throughout the country, because it seems like, at least in my experience, a lot of courts are kind of latching on to prior C.H. Robinson cases. There's this case called the Schramm case. This was from a decade or so ago. I think it was out east. But this was a federal court case where C.H. Robinson was implicated in a negligent selection type case. And the question was posed, what duty do brokers have to vet the motor carriers that they put out on the road? And the court in that case set out a pretty, in my view, easy to follow standard. It was essentially what you said, Matt. Either subscribing to a service that does this for you. That's frankly the easiest thing. There are several services out there now that do this for you if you're a broker. But you could do this literally in 30 seconds yourself. It's essentially, the court said in that case, you got to check this motor carrier's DOT number. First of all, make sure it has a valid DOT number. Second of all, make sure that it has the proper insurance on file for whatever freight it's hauling. And frankly, if it doesn't have if it has a active operating authority, it's going to have the right insurance, because otherwise they wouldn't have active authority. And then it's making sure that they are not subject to an unsatisfactory safety rating. Those are the three things that the court mentioned. Yeah. Like I said, you could check that within 30 seconds if you just type in the carrier's DOT number on the DOT website, and then you're done. I haven't seen any court in the country take it any further than that, although you'll hear a lot of brokers and shippers express concern about, we got to look at the carrier's CSA scores and get into the details about their out-of-service rates. I don't think we're there yet.
No, I think you're right. I think, as you've outlined this, it's, if you were going to hire a contractor to go work in your parents' house, like, what would the level of effort you would have in saying, is this someone I want in my parents' house? Well, you'd probably call them and say, can I speak to you? And just talk to you. And then, do you have insurance? Like, can I see a copy of your certificate of insurance? Great. But it's not. It is common sense to a certain extent, but the liability you face on the other end if you don't do it right. So if you're outsourcing all of your compliance to some foreign area, you don't have any control over that, that's when liability comes knocking. And especially if your motor carriers are carrying, statutory minimums, you're going to get dragged into a lawsuit. Maybe you get it dismissed. Maybe a motion for summary judgment, you get out of it. But still, it is expensive to litigate and win. It's not cheap to do any of this stuff.
The other factor that comes into play here is, and we haven't seen it really go anywhere yet, but I will be interested to see if it gets any legs. And that is, and I don't know if you've seen any of this, Matt, but we've heard talk over the years about a national hiring standard. That's the phrase that's used for this, but it's essentially federal legislation where some senators or Congress folks will pass a bill that kind of sets the standard for what brokers and shippers have to do when vetting motor carriers, so that we can potentially avoid this patchwork of state laws where each state gets to decide what the standard is. I think that's been proposed probably 5 or so times. It hasn't gone anywhere yet, so we're not there yet. But that's one potential way we could do away with this concern about a patchwork of state laws, I think.
And you still have intrastate drivers are going to have the recommendations and the rules about the state that they operate. Yeah. It will always be a patchwork. Everybody, it will always be a patchwork. Someday, maybe not. But this
is the nature of transportation. It's
right.
Constant struggle between interstate and intrastate commerce and whose laws apply. It's an issue that crosses all kinds of issues, including safety regulations. Okay, so if you're a carrier, let's turn the tables here. If you're a motor carrier, Matt, what can or should you do to make yourself more attractive to brokers and shippers that are looking at you for business?
I love this question, and here's the answer. Safely deliver freight on time and undamaged. Like, you want to be attractive to a broker? Do your job safely, do it on time, and don't damage anything. These are the quintessential things that make good carriers great carriers. Is that consistency, that level of communication. I would lean on how much insurance you have. I mean, seriously, I'd be like, I carry $10 million. I carry $10 million. Really? Okay. And I got a $5 million umbrella. We're ready to go. Those are the things that I would look at, but also, what is the equipment that you're running? I mean, if you are a carrier and you have extra trailing capacity, that's really compelling for some of the brokers out there. So it's going to depend. Obviously, that's the answer for everything. But the simple blocking and tackling of delivering freight safely, on time, and undamaged is always going to be a winning recipe.
Yeah, it's all about reputation and, those brokers and those shippers' experience with you. And as you said, Matt, just, doing things the right way and delivering their freight safely. That will go a long way. And then obviously it doesn't hurt to to make sure your DOT number is active and your operating authority is active, and that you have the right insurance on file and you don't have an unsatisfactory safety rating. Those things would be attractive.
I think you're right.
All right. So, okay. So that's a very high level look at broker liability, at least the kind of negligent selection side of things. I did want to spend a minute to talk about a somewhat related issue that has come up recently, and this is the idea of unauthorized brokerage or double brokerage. We had one individual on LinkedIn who asked us to weigh in on the legality of co-brokering or double brokering. I thought it was an interesting question.
Yeah.
We recently did an article on this. We have an ongoing segment on our website called Compliance Myths, and we tackled this issue of double brokering. You hear a lot of folks in the industry up in arms about double brokering. I'm curious your thoughts on the topic, Matt.
Well, just looking at co-brokering to begin with. So co-brokering, as far as I understand it, is every party knows who's involved. Everybody knows the insurance that they have. Everybody has kind of agreed to this thing. And where you have a double brokering situation is somebody doesn't know you did it. And that's where the problem is that we in supply chain and just safety generally, we want to know who's touching our stuff. We want to know what's happening down this process. And one of the challenges of deregulation, and again, I hate to go back to 1980 and say everything that we deal with today is based off of 1980, but to an extent it is. And when you made it so that you could have everybody moving freight the way that they do, it's a highly fragmented business. And because it's so fragmented, you can infiltrate other ways to find ways around the regulatory network, like possibly like a dispatching company or something similar that touches something, but not necessarily the freight. And so you don't have to want to be liable to carry the insurance and all that stuff. But my opinion of this kind of stuff is if you're going to be in the brokering business of either drivers or freight, you probably ought to be regulated and you probably ought to be paying adequate amounts of insurance.
Yeah, and to your point, Matt, the other thing about deregulation is it made these issues primarily a private issue. In other words, the government's not going to get all that involved, although they still issue operating authority. Brokers still have to have operating authority. But I think the thing that I always bring up when I hear folks up in arms about double brokering is that's a private issue. You're not going to get any help from the FMCSA when it comes to double brokering. It is not illegal per se to double broker loads. As long as all of the brokers in that chain have the operating authority that the FMCSA tells them they have to have, then there's nothing illegal about that. It's very well a breach of the contract that you have in place.
Exactly right.
Yeah, and so that's your remedy is to go after that first broker that you had the relationship with. But
the challenge is maybe you don't even know what happened.
Exactly.
Until something catastrophic happens. And then they say, okay, well, let's see who we can tag. And then you get the lawyers like me and possibly you saying, hey, let's do some more due diligence into this particular organization. But to your point, this is a breach of the contract with the shipper. And they're not going to be happy you did it. And they're going to kick you off.
Well, and that's not, obviously not to say that it's not a big problem. It is a big problem. It's going to cost you a lot of money potentially when there is an accident. But it's a private issue that you have to take up with whoever it is in the chain that you have the relationship with. So, kind of similar on a somewhat related note. So the FMCSA recently came out with a notice asking for comments from the public on so-called freight agents and dispatch services, as you mentioned, Matt. And it seemed to me they were a little vague in their notice. It seems to me like they're probably after dispatch services that are trying to skirt the operating authority requirement. They're calling themselves a dispatch service where they're working for a particular shipper, and they're avoiding having to go get operating authority by claiming that they're a dispatch service. So it looks to me like the agency is potentially going to be cutting down on that or trying to cut down on that by regulating it more closely. Is that your take on it?
Yeah, I mean, dispatching companies are really interesting. So the way I've heard them characterized, and my familiarity is not super strong with that organization style, but they will have access to a bunch of drivers, and the drivers are gonna get the deals with moving the freight, but the dispatching company is gonna help with scheduling, they help with communication, they're gonna do some of the back office work, just like you'd have with a dispatcher for a normal trucking company. They're just making sure things are moving. But as they get more into what they do, it begins to look a lot more like being a broker. It looks a lot more like being a broker. When it's all with a trucking company, with a dispatcher as a central hub and all the drivers underneath that same authority, that makes a lot of sense. That same apparatus begins to shape up in the independent or a bunch of small companies, and you start asking those questions like, "What are you?
Yeah.
What are you doing?"
And why are you doing it? I mean, the thing that always amazed me is it doesn't take much to become an authorized broker. You have to have you file an application with the FMCSA, and you have to have a bond. I think it's $75,000 bond on file, and that's it. And you got your broker authority, and you're good to go. So not a lot that goes into it. So getting that authority is not that burdensome. Barry here has another comment.
Yeah,
Let's
Barry.
see what he's got to
I love
say.
Barry.
Also, on the FMCSA Safer site, if you want to get in depth, you can click on and see every violation the carrier has had and which truck got what violation by their license plate number, and see who's hauling load. Then simply go to the Safer site, see if the vehicle has had a violation within the last 6 months or, I believe, 2 years. Yeah, I mean, that's exactly right. The Safer site, you can get as deep as you want to get if you're a broker or carrier when you're vetting the motor carriers. Again, not legal advice from either me or Matt here, but my concern is kind of that balancing act again, because you go to the Safer site, you see that they got an active DOT number and that they don't have an unsatisfactory safety rating, and so you've kind of met that standard that the courts have set to date. But then you go to the next step, and now you're starting to dig into the specific violations, and you're starting to call the carrier and say, "Hey, I saw this driver had a violation. Can you work with them to deal with those issues?" Then you're starting to push yourself more towards that joint employment exposure, which I worry about on the other side of things. So you have to figure out what the right balance is. And in my view, you just got to document what your protocol is going to be for selecting motor carriers and stick to it.
And what I'd also mention, as Barry brought that up, is a lot of this data that people are paying subscription services for. So there's software you can subscribe to that just synthesizes the Federal Motor Carrier Safety Administration data. You can do this stuff without having to pay those fees because it's all there. And I still think, to your point, like, you still call them, you still talk with them. You don't have to say, "Well, I saw you online, it's got to be fine." And everybody's going to have safety violations when it comes to FMCSA. One of the things we talk about is like Brake Safety Week or International Road Check. You see numbers that are just staggering. 12, 15, 20% of vehicles inspected are unsafe and they're knocked out of service. This is the nature of our supply web. This is how it works. Most people do not maintain their assets the way they're supposed to.
Yeah.
The majority, a significant portion that should concern everybody, do not.
Yeah, exactly. And I think the good thing is, because if I'm a shipper or a broker, I'm asking myself, well, where do I draw the line? I look online, I see all of these maintenance violations, but everybody's got maintenance violations. So how do I know what's good or bad? And so the thing I'll mention is that the DOT sets metrics for these types of things. They set the national average. So if you get on the Safer website, you could see what a particular motor carrier's vehicle out of service rate is as compared to the national average. And if they're doing better than the national average, then you got an argument at least that they're doing better than average. I don't know if that's the argument I'd want to hang my hat on, but at least it's something.
Absolutely.
All right, Matt, we're running out of time. Really appreciate you joining me. I think it was a great conversation to kind of talk about these exposures to brokers. So thanks so much for joining me, and hopefully we'll have you on again soon. Where can people find you again if they're looking for you?
Well, they can find me here talking to you, which is fantastic.
Yeah, right now.
But you can find me on LinkedIn. You can find me. I think I'm on Facebook still. Matthew Leffler is my name. You got Twitter. You got TikTok. Armchair Atty, ATTY. Why? Because ATTY is the abbreviation for the word attorney. And I am excited. I talk about all sorts of things like non-competition agreements, post-employment restrictive covenants, and I want to make you a better negotiator. Everybody, I want you all to be better negotiators.
You also talk about Lord of the Rings. I should have mentioned this earlier. That was one of my favorite shows of yours. You spent a whole episode just talking about the Rings of Power show.
Oh, it is. I want to like it. Oh my gosh, Brandon, I want to.
You don't like it? I thought episode 4 kind of redeemed the show.
It has, but like every single time they face adversity, they just immediately overcome it. Like, I'm locked in a tower. No, I'm going to leave. I'm locked in a cell. No, I'm going to leave. Oh, there's a giant snow cave troll. No, it's dead. It's the sea monster. Don't worry, we moved past it. It's done. We're done. We're gonna swim back from Valinor to Middle Earth. That'd be great.
Well, hey, my point is, if you like that type of content, Matt offers that as well. So check him out.
Absolutely.
All right, Matt, appreciate it. Thanks for joining me. All right, that's going to wrap things up for this show. Appreciate everybody tuning in today. Again, go to trucksafe.com if you're interested in learning more about these types of topics. Again, we've got a bunch of articles on broker liability, just to name one topic that we've recently addressed. We also have that detailed article on that ELD rulemaking, the advance notice of proposed rulemaking, so check that out. Also, be sure to follow us on social media. We are on LinkedIn, Facebook, Twitter, YouTube, and TikTok. If you want to follow us on any of those channels, we're constantly pushing out breaking regulatory news and our analysis of it. The last thing I want to mention is something new we are launching, which is our Trucksafe Compliance Boot Camp. And I'm going to roll a video here about it so you can check it out. Hey everyone, Brandon here with Trucksafe Consulting. I wanted to take a second to tell you about our Fleet Compliance Boot Camp, an immersive 2-day conference that we hold in person twice a year. This boot camp is designed to equip a small group of trucking professionals, whether it's an owner, safety team member, dispatcher, risk advisor, or otherwise, with the knowledge and tools they need to develop and maintain a cutting-edge safety program at their fleet. This isn't your typical conference where you take some notes and try to implement what you learned back home. Boot camp is comprised of discrete and intensive sessions targeted at key areas of DOT compliance, where attendees not only receive industry-leading educational content from industry experts, but more importantly, get hands-on and participate in specially developed exercises like driver log audits, accident simulations, driver qualification reviews, and more, all to help equip them to apply these lessons at their own fleets. We hold 2 boot camps each year, one in Indianapolis and the other in Orlando, and we cap attendance at 25 so that we can offer more personalized instruction and assistance and to facilitate more collaboration among our attendees. In addition to the main event, we also offer an optional half-day masterclass, which we limit to 5 attendees for an even more in-depth experience. All boot camp attendees receive top-of-the-line compliance-related content, like detailed topic outlines, workbooks, a full library of DOT compliance forms, and more to kickstart their compliance back home. The Fleet Compliance Bootcamp is ideal for folks just getting into trucking and also those who play a role in an existing carrier's DOT safety and compliance program. Our goal is to help demystify DOT safety regulations and to help folks implement robust safety programs to keep them compliant and out of the crosshairs. We hope to see you at one of our upcoming events. Check out the details and register online at trucksafebootcamp.com. Thanks for watching. All right, so that's going to wrap up the show. Appreciate you all joining us. Tune in next month for our next show. Again, we do these monthly. You can check out the details, add it to your calendar at trucksafelive.com. See you later.